GRL's Victory Vault, where we dive into the stories behind the cases that have made a significant impact on our clients' lives. Hello and welcome to another episode of GRL's Victory Vault, where we dive into the stories behind the cases that have had a positive impact in our clients' lives. I'm Grant Gangestad, your host, and today we have Colin Murphy with me, partner at GRL Law, who fought on behalf of a client in this particular case in a theft of an employer kind of situation involving significant potential prison and monetary penalties. Colin's determination and legal acumen were key in avoiding an outcome that could have financially devastated his client for decades, really.
For sure.
So, welcome, Colin.
Yeah, thanks for having me.
Let's just jump right in. Let's get some background on this case. Tell me kind of what happened, how you became involved.
Yeah, like most cases, we get a call, and usually it's in the early stages of an investigation. Maybe law enforcement's reached out to the client. Maybe there's been an arrest, maybe an initial appearance. It takes several forms. But I've got a call from a client who appeared that they were going to be charged with Class C felony theft. So that's first-degree theft. Significant sum of money involved, and so looking for a defense and representation. But when we're looking at it, we don't know a lot about the case yet, but we knew that it involved significant sum of money taken from an employer over several months, small amounts that added up to about six figures.
Okay, so significant amount
Significant,
of money.
and multiple takings over that period of time.
Okay, so small increments, somebody found it in the accounting or something like that.
Exactly.
Okay.
Yeah, audit that led to the discovery, and then investigation kind of unravels, and then we get the charge.
So we get the charge. You start investigating. What do you find? What does your investigation reveal?
Yeah, one of the first things was the charge that the police make, and this was kind of the conversation at the outset of the case, which is we don't know what the county attorney's office is going to do. We know that the police have charged a single count of first-degree theft, but the county
first-degree theft is $10,000 or more.
$10,000 or more.
Okay.
But we knew that this
And that's one single charge.
one charge, but it involved dozens of takings. Again, small amounts that the cumulative effect of that is more than six figures. But so when we first get the case, based on the investigation by police, we're just dealing with one count. Based on prior experience, though, we know that once the county attorneys get that charge from police, they may determine that there's the potential for other counts to come into play. And so we're always warning of that because we don't know where it's going to go. And in fact, that's exactly where it went. And so county attorney ends up charging two additional felony counts. One, we anticipated ongoing criminal conduct. So when there's repeated things, like in this instance, over a significant period of time, county attorney's office will usually charge ongoing criminal conduct, and that's a Class B felony, so a step up. But what we didn't expect, and this is kind of where the case got interesting, was there was a money laundering count, because there was an allegation that some of those funds had been moved onto a debit card, and that debit card may have then been transferred to a bank account. And so they were able to at least make the allegation that potentially that amounted to money laundering.
Okay. Let's talk about the different counts here for a second. Class C felony, the theft charge. What kind of penalties is somebody looking at for that?
So, that can be a term in prison up to 10 years. It's a fine of a minimum, probably a little over $1,000, up to $10,000. So standard, criminal penalties for that Class C felony.
And the ongoing criminal conduct would be the B felony.
B
and
felony.
That's sort of this happened over a long period of time. They enhance it because somebody is repeatedly doing the conduct. They can lump that all together, call it ongoing criminal conduct. And what are we looking at for those kind of penalties?
Yeah, that ends up being the possibility of a significant prison sentence up to 25 years. There's no fine with that, but that, The idea being, if somebody's going to prison for a long time, they may be unable to pay that off. And so I think that the legislature makes that fine no fine because the person is potentially facing long prison sentence.
And then we've got the money laundering count, which is kind of where this one takes sort of a turn, right?
Right. And so we don't see a lot of money laundering, but when we do, one of the consequences of that is there is a fine up to $10,000 or twice the amount that is essentially laundered. And so depending on the amount of the thefts and the amount of the takings that they can attribute to money laundering, that can be a significant penalty. So in this case, it did exceed that $10,000 amount. So we were looking at roughly $20,000 to $25,000 that they could tie to the money laundering count. So take 2x that, you're looking at between $40,000 and $50,000 as a potential fine.
So, so say, we'll just throw out a number here, example, you stole a total of $50,000. The fine amount can be up to twice that, right?
If that's the amount that was essentially transferred to an account or fits the elements of money laundering, yeah, it can be twice that, just the fine.
So twice the $50,000, just the fine could be up to $100,000.
Correct.
Okay. There's another piece of this too.
There
right?
isn't. That's where it gets really interesting because the Iowa law provides for a separate civil penalty. It's almost like a punitive damages item of punishment, but it's weird that they call it a civil penalty because it's really a financial penalty, a punishment, but
Sure.
That can be up to 3 times the amount that can be attributed to money laundering. So in your example, if you've got $50,000, they can double that for the fine, turn it into $100,000. They could triple it for a civil penalty. So you're looking at 5x, potentially, $250,000 in fine and civil penalty associated with that on top of a 10-year prison sentence.
So 50,000 turns into 250,000.
Right.
My understanding, and correct me if I'm wrong, is that there's also what's called restitution.
Restitution. So any amount that they can attribute to the thefts, you'll have to repay that as part of the, making the victim whole. And so the court can order restitution on top of fines and civil penalties.
So if you took 50,000, potentially 6x that for 300,000.
Correct.
So you've got the double the fine, triple the civil penalty, plus you're paying back what you took.
That's right.
Okay. So that's kind of insane and mind-blowing. But tell me how this kind of unfolds. What is that set up for you here?
So when we start to unpack the case and, like we approach everything here at the firm, we're looking at our plan A is to see if we can develop a defense to it. Is there a way to generate reasonable doubt, as to the client's guilt in the case? And so there was pretty decent police work, to be fair, in the case. And so they were able to determine a number of things that made trial probably, reasonable doubt probably difficult to establish, unlikely. For example, there was a certified fraud examiner who looked at all the transactions and were able to determine, pretty clearly that, these takings did not occur before the person became employed. They stopped shortly after the person left employment. And so, it's starting to narrow the focus down on a particular individual. There were some other transactions that could be identified. Obviously, the movement of money from a debit card to a bank account and being able to trace that it certainly starts to narrow the focus. And so after that investigation, it was pretty clear that we need to be probably looking at Plan B, which would be how are we going to mitigate the circumstances for this individual? Because again, significant possible prison sentence, obviously the financial consequences that we talked about, that's a lot.
So they follow the money, and the money leads to probably not a great trial case.
Correct, yeah.
So now we're looking at what can we do to avoid some of these overwhelming consequences. So, I mean, give me a sense of what does that do to a person? I mean, if they get dinged for all of this stuff, what is he? I mean, this is gonna ruin him, right?
Well, there are in this particular case, the person didn't have any significant prior criminal history. And so there are sentencing options. Each one of those cases, each one of those counts, the court had the opportunity to send the person to prison on each one of those counts, run those concurrently or consecutive to each other. So, at the same time.
10 years, 25 years, and run them all either at the same time or right one after the next. Right?
Correct. And at one point, that was a factor in the plea offer that we were receiving from the county attorney's office, where they would limit themselves to concurrent prison sentences. And so that is somewhat of a concession, but what we're trying to avoid is prison altogether. One, because in situations where a person has a family, for example, or other considerations where perhaps a lengthy prison sentence isn't something that is really going to rehabilitate the person or protect the community. We want to avoid that, but if we can,
that's job number one.
Job number one, keep the person in the community. Second thing, though, is will that person come out on the other end of this case with a conviction? And so these are deferred judgment eligible counts, and so
avoiding a felony conviction.
Avoiding a felony conviction. So the idea would be, can we put the person on probation? Once they successfully complete probation, at that point expunge the felonies from their records so that they can then say, I haven't been convicted of a felony or 3 felonies.
And then secondary to that, even, so we got avoiding prison, avoiding felony conviction. Now we've got all these potential monetary penalties too.
Right.
We're talking potentially hundreds of thousands of dollars,
yes.
Right? That could bury you for decades, right? Even if you avoid prison, you avoid a felony conviction, you're potentially looking at not being able to dig out of that hole if they stack all those consequences up.
Correct. And that started to become a real concern as we shift from developing a defense to mitigating the consequences. So the county attorney is going to come back to us eventually and say, here's what the state will recommend. If you want to plead to the Class B felony, the ongoing criminal conduct, you're not going to be able to recommend or ask for or receive a deferred judgment at the time of sentencing. So if we wanted to plead to one of the felonies, and it happened to be the most significant one, we couldn't ask for a deferred judgment. So, and the state's going to be asking for prison at the same time. So we are limiting.
So as part of the agreement, they're saying, we'll let you plead to one, you can't ask for a deferred judgment.
Correct. And then the other option would be you could plead as charged to all 3, and we'll cap ourselves at concurrent prison sentences, but that would give us the opportunity to at least ask for a deferred judgment. So again, keeping in mind the idea we want to try to avoid prison and avoid felony convictions when we successfully complete probation, we're going to take a look at that second option.
So giving yourself a shot to at least avoid those felony convictions on the backside of probation.
Yes.
So what do you guys do? How does this play out?
So obviously we come back now to the financial piece, because restitution in this case was 6 figures. That's going to have to be repaid.
Regardless.
Regardless. The court's going to order it, and there's no way to really discharge that. It's going to be a financial obligation that you're going to have to pay off. And something that if we were to receive a deferred judgment or even a suspended sentence, you'll be on probation probably as long as it takes you to pay that off. And so, it's going to take several years, and maybe probation gets continued. It's hard to predict what's going to happen, but when it became clear that large amount of restitution was going to be needed, we start taking a look at, is there a way to possibly pay that restitution prior to sentencing? The idea being, if we put the client in the best position possible to repay the financial harms that were caused by the thefts, it puts them in probably the best position to then ask for a deferred judgment, and maybe at the end, if the court didn't grant a deferred, to be able to suspend that prison sentence so that they can basically be supervised on the street, in the community, without being incarcerated.
So the restitution piece, making the employer whole,
Correct.
basically, you do that prior to the court even pronouncing judgment, showing the court that, hey, we're taking this seriously, I'm doing what I can to make this right with the employer.
Yes, and that was something that we had not approached in the past as a strategy, but in this case, I think that it ended up being it helped produce a favorable outcome in terms of sentencing, because it comes with some risk, because you don't know if we get an order from the court that says the court will accept restitution ahead of sentencing. So we're coming into that hearing having already paid that without any expectation of what's happening next. So could the court have sentenced this individual to prison despite having paid that restitution? Absolutely, that's a risk. But it ends up being, it puts him in the best position possible.
Sure. So you pay the restitution.
Prepay the restitution prior to sentencing.
We're going to sentencing. What happens?
So one of the issues, again, is the financial consequences. So we're looking at a situation where now that we've taken 1X off the table, with the payment of restitution, we're still looking at the possibility that the court could sentence him up to the maximums permitted by law. So a situation where possible 2X fine and 3X on the civil penalty. What was interesting about the fine is the language is not mandatory. And so the court does have the discretion to suspend a fine in that situation.
Or a lesser fine, or something not up to that 2X number.
Correct, yeah, the way it read is it could be up to $10,000 or twice the amount. So there doesn't appear to be, most Class C felonies have a minimum. This money laundering did not really have a minimum. The court could have given 0, or because the amount of the amount laundered exceeded $10,000, it could be up to 2X that. So the court ended up not imposing the 2X fine.
So they didn't impose the 2X fine.
Didn't impose the 2X fine.
Wasn't mandatory. They had some discretion there.
Had discretion, exercised discretion, which is what we asked the court to do. Ended up imposing what essentially is the mandatory minimum for a Class C felony of a little bit over $1,000.
And so the state was asking that these be imposed.
Fully.
Full boat, give us the whole shebang, give us all the money that you can give us.
That's right. The state asked for twice the amount.
For the fine.
For the fine.
Okay.
And then we come to the civil penalty, and that's where it got interesting, because that law has been on the books since 1996. There is no case law in Iowa on the imposition of that civil penalty under these
Whether the
circumstances.
court has to impose it.
Correct. And it has some strange language, even though the fine uses a may instead of a shall, so you can see where it's discretionary with the court. That civil penalty language just said that is subject to. And so what does that mean?
Does that mean they got to do it, or does it mean that they can do it? Is it discretionary? Is it mandatory? We don't know, right?
Right. So the legislature, in basically back-to-back paragraphs in the same code section dealing with money laundering, says that the fine is basically discretionary, using may, but the civil penalty is subject to. What does that mean? Basically in the same context, one we can clearly see as discretionary, but we don't know if the civil penalty is discretionary or not. So now we've got it's a huge amount of money.
Sure. And the state's taking the position that they have to impose it, right? The court has to impose it.
Initially, going into sentencing, that was the state's position. Now, I give the court credit because there's not a lot of direction in the statute. There's not a lot of direction in the case law. Court asked the parties to brief it. So they're going to ask us to do some research. So we're going to be looking at maybe how if there's some similar code language under federal law, maybe how other states are handling it, and we're looking at it from that perspective. I think the state was going to reach out to the Attorney General's office and get some direction from them on civil penalties. So while we're briefing it, we get some information back from the county attorney's office that they're going to withdraw the request for the civil penalty. And so even though the court's asked for briefing, they withdraw the request. That's positive, up to that point, because now they're at least not asking for it to be imposed, but the court could still impose it if the judge found that it was appropriate under the circumstances. We put our best brief together that we could, saying that we didn't think that it was mandatory and that there were reasons not to exercise discretion and impose it.
So we're talking about the 3X piece here, the biggest
Correct.
Financial piece out of all of it.
That's right.
And so ultimately, court in sentencing, let's talk about the felony conviction first.
Correct.
Do we get a deferred or not?
We do not get a deferred.
Okay.
You put our best foot forward on that. Person's clearly eligible for a deferred. I think the court took into consideration the period of time over which
severity and the continuous conduct.
you also had some feedback from the employer and other people involved in the organization that were asking the court to impose a prison sentence.
So we don't get the deferred, so we have a felony conviction. Now, do we get a prison sentence or not?
Correct. And so that ends up, the judge suspended prison.
So no prison.
No prison.
Good result.
Great result.
And now we have the fine. I think you said the court did not exercise double the fine. They gave sort of the mandatory minimum for what otherwise would be a Class C felony.
That's right. A little bit over $1,000.
And we avoid this 3X piece on the civil penalty.
On the civil penalty.
So what was going to be, you're going to get everything. You're going to get, potentially prison, this 2X fine, restitution, and the 3X civil penalty through some tenacity and some good lawyering and some legal acumen. You were able to avoid those significant consequences.
And and looking back, and you're familiar with the process, and I know that we've probably talked about it, throughout the podcast, how we roundtable certain issues. When it became obvious that this was going to be an issue, I'm reaching out to everybody in the office. We're putting, it's the hive mind, the collective. We're getting input, figuring out best ways to argue this, and so I think it's clearly a group, effort and a great result for the firm and the client. But it's an example of even the novel situations that we're faced with, where we've got some very good lawyers in this office that when we put our mind to achieving a result, I think that this is a perfect example of that.
Absolutely, a testament of putting the work in and getting a good result for a client who was probably truly deserving of getting a little bit of a break here.
Absolutely.
Well, Colin, it's been a pleasure chatting with you
Yeah,
today.
thanks for having me.
As criminal defense attorneys, obviously, we're always striving for those acquittals for our clients, and obviously, even though this case didn't turn into an outright acquittal, it's good to remember that even when that dismissal isn't there, a strong legal advocate in your corner can help get that big impact, that huge penalty off the table, including the monetary stuff in this case, which was kind of a very novel situation. So thanks to you, Colin.
Thank you.
And a big thanks to our listeners for tuning in today. If you like what you're hearing, leave a review, give us a like. Tune in to the next episode of GRL's Victory Vault, and we'll dive into some more stories about the cases that matter.